As today marks exactly 9 years since Bafana Bafana star Senzo Meyiwa was killed, accused number 2, Bongani Ntanzi's confessions are once again in the spotlight. Lieutenant Colonel Mohale Raphadu has taken the stand today as the trial within a trial continues. Raphadu is testifying about Ntanzi's alleged second confession statement, which he made to a police officer at Moroka Police Station. The statement was made before the confession statement he made before Magistrate Cronje, and his alleged lawyer at the time, Dominik Mjiyako, reading from the pro forma, Raphadu said that Ntanzi allegedly indicated that he was also not assaulted, influenced or encouraged to make a statement.
Have any promises been made to you by any person? If so, if you should make a statement?
Ingaba ikhona yini ithembiso ezenziwe kuwena umuntu nje nomkhona nje umuntu owenze ithembiso kuwena ukuthi wenze istatement? Impendulo yathi
no.
Yathi cha.
If so, what are the promises not applicable?
Uma kunjalo ke isithini ithembiso akukho lokho noma azikho?
To what extent, if at all, did these promises lead to your decision to make a statement not applicable?
Uma kulokho ke lezi thembiso lezi ke ngabe zenzeni ke ukukholela ukuthi ke uthathe isinqumo sokuthi wenze lesi statement akukho ke lokho ngoba eshilo ukuthi ithembiso azikho.
Do you expect benefits if you make a statement? No.
Ingaba ubheke noma ulindele inzuzo yini uma ngabe wenza istatement? Cha.
If so, what benefits not applicable?
Uma kunjalo ke yipi inzuzo ngoba ke bese the cha kuthiwa ke ayikho ke leyo.
To what extent, if at all, did the fact that you expect benefits influence you to make a statement? None.
To speak to legal analyst Nthabiseng Dubazana on the events as we saw and heard them in court today. Thank you very much for your time this afternoon. Perhaps let's start with an issue that was raised by the defense advocate Mgomezulu on behalf of accused number 2. He took out a document for the witness to read. So on the 16th of June, accused number 2 was arrested for being in possession of ammunition, and he was never charged until the 19th of June. And the document that was read to the court by the witness currently on the stand is dated 19 June 2020 at Pogeng, and it was made at 11:45 in the evening. However, the date of the arrest in this current case is the 16th of June 2020. What should we understand about this?
So the importance of this document is that it's what we call a rights sheet. If you were to be privy to seeing it, you would have seen that it's written in red and black. So the importance of this is that it shows when the accused person was arrested. Now, in terms of Section 35, and in terms of the Criminal Procedure Act, you have, as the person who's been detained or arrested, 48 hours for you to be seen in front of a magistrate in order for you to apply for bail, for charges to be put to you, and etc., etc. So this proves that the time allotted was over 48 hours, albeit the 16th of June, if I heard properly, was a public holiday. So that we can already exclude it. It's not counted within the days wherein he was supposed to appear in front of a magistrate. But then we have the 17th and the 18th. Why did those 2 days lapse before the accused person could appear? So if it turns out, when we look at the calendar at the time, that those 2 days fell within a weekend space, then perhaps it could be argued by the state that they couldn't bring the accused before the court because court wasn't sitting. Now, the importance of this is that if 48 hours has passed and you haven't been put in front of a magistrate to either apply for bail and all of those things, the likelihood of the case to be thrown out is very high because that arrest will be deemed unconstitutional.
In terms of the likelihood of the case being thrown out being high, we also found out through Advocate Mgomezulu on behalf of number 2 that Bongani Ntanzi's rights were explained to him in English. There was no interpreter. He then put it to the witness that can he confirm whether he understood his rights, or rather it cannot be confirmed if he understood his rights because the language that was used is not his mother tongue.
Yes, that's very important. And here's another thing that needs to be probably brought to light. What is usually the practice in terms of people getting arrested? Your rights are not read to you at the moment of arrest. What happens is that you are arrested and you are driven around in a police van to go point out to this, to go give evidence about that. And when you reach the police station, that is when your rights are read out to you and you're made to sign the rights sheet that was presented in court today. So what is not known, I guess, by the SAPS is that any evidence that was attained from the accused person prior to the rights being read is deemed inadmissible in court. It's a court matter that addressed this issue. So now what they're trying to do in this trial within a trial is to establish if these confessions and everything that the pointing out that has been dealt with was done prior to the rights of the accused being read to them. And if they were indeed done before he did the pointing out and the confession, did he understand? And if he cannot prove either of the two, it means whatever that was said and done by the accused, this court cannot accept as evidence.
Essentially, also, the defense is arguing that the accused number 1 and 2 made these so-called confession statements under duress. This is what we heard on behalf of accused number 2 in terms of his version of events about the torture that he endured. Let's revisit that moment.
The version of the accused is that when he was booked out from Moroka Police Station, he was taken to Randfontein, where he is employed, or where he was employed. And from Randfontein, from Carltonville, I beg your pardon, from Carltonville. From Carltonville, he was then, at Carltonville, he was transported by Mabena and Mohanu. You won't dispute that?
That I can deny. I can't deny. I wasn't part thereof.
Sir.
When they were still at Carltonville, Brigadier Kininda arrived, and he was in company of a lady, Mohola. And at that time, the accused was transported with a white Toyota Fortuner. You won't dispute that?
I will remain silent about it. I do not know.
When Kininda left, Brigadier Kininda left, they then took a direction towards Albertine, where they stopped at next to a filling station, which was opposite a company that is manufacturing steel.
That I don't know.
He was choked, tortured, and assaulted by Mabena, Buthelezi, and Jonathan. You won't dispute that?
I do not know about that.
So they insisted that he should tell them the truth about the murder case.
It goes on further, and Nthabiseng Dubazana, to explain how he was actually tortured in detail. How will this assist the court, or what will the court use in coming to a determination of whether he indeed was made to sign under duress? Because the witnesses and previous witnesses that we've heard all say, well, accused 1 and 2, they made their statements freely, voluntarily, and here we are hearing the version of events that it wasn't. So what will assist the state in coming to a determination about where to go?
So now the court has to weigh the evidence of the witnesses and the accused persons and decide which one has more probative value versus the other. And then if indeed the court comes to the conclusion that the statement was made under duress, it means it wasn't done freely and voluntarily, which is one of the core requirements when you're making a confession. Therefore, that confession cannot be admitted into evidence for this matter. And it goes back to what we were saying earlier, that everything that was said by the accused, the pointing out and all of those things would therefore fall under the same umbrella, that it is inadmissible before this honorable court. The only downside in the manner that the torture and the assault and the shooting happens in such matters, it is not made in a manner that's going to leave any markings on the accused. So the state usually says, but there's no evidence that there was a bruise or there was a tear in the skin, etc., etc. It is used in a manner wherein they are dunking this person in water, so that it does the effect as if the person is drowning. And therefore, as a result of the fear of drowning, then they end up giving evidence in the manner that is requested by the person who is inflicting this harm on this person. So this is the part that us as defense attorneys actually struggle with, because if you don't have any markings, it is extremely hard to prove that you were tortured. But the thing is, it is a known fact. Of course, it's not something that you can say, I know for a fact it happens, but you know it happens in terms of the torture style that is employed by the SCPS. It's just that it's difficult to prove.
Thank you very much for your contribution this afternoon. Nthabiseng Dubazana is a legal analyst.